Okay, so let's discuss the very important terms that you're going to make yourself familiarize with our topic on contract. So what is contracts? It is defined as meeting of minds between two persons whereby one binds himself with respect to the other to give something or to render some service. This means to say that there must be a minimum number of parties in a contract, and that is at least two persons. So it might be two or more persons whereby one binds himself with respect to the other. So you cannot make contracts to yourself. It is so absurd. Okay, so there must be a minimum number of parties, and that is two persons. So on the other hand, agreement are the terms agreed by parties which cannot be enforced before the court of law. No? Okay, so agreement, unless maybe it is transferred into a public document or being notarized. Another term that you have to make yourself familiarize is the aleatory. Aleatory is a contract classified by risk involved. It depends on an uncertain event or contingency, both as to benefit or loss. So one example of this aleatory contract is the contract of insurance, wherein the insured take the premium or pay the premium in order for them to insure the risk. So it could be a fire, it could be life insurance, crop insurance, and many other type of insurance wherein you are expecting that something will happen. So the risk will going to happen, and that you will be given an indemnity in case that the contingency or that risk will going to arise. Okay, so next term is commutative. It is when the undertaking of one party is considered as equivalent of that of the other. So example of commutative is the sale or lease. Another term that you have to familiarize is customs. So as discussed in our previous lessons, so customs are habits and practices through long usage have been followed by society as binding rules of conduct. So it is based on the habits and practices with through long usage. That means to say this kind of practices and habits had been passed down from one generation to the other, and that becomes the rules of conduct of society. So it is binding because we know that the sources of obligation could be the law, the contracts, and the customs. So if it has been accepted and practiced in a society for a long period of time, so it becomes binding. So it serves as a contract for those members of the society. So it has the force of law when recognized and enforced by the law. Okay, so sometimes there are some laws that have been based on the customs of one area or society. Another term is morals. Morals deals with norms of good and right conduct. Okay, so it is what is good, define what is good and what is right, and evolve in a community. So there are some that it is moral in some areas or society, but becomes immoral to other society. Just like the practice of polygamy class, no? So there are some society, there are some group of community who accept, who agreed or believe that a man can marry, for example, as much as he can, or at least four or more, as long as he can finance the needs of his wives and the children. But for some other members of community, so it is immoral because other community Especially Christians believe that marriage is holy, no? So, there's only once ka lang ipakasal. So, pag sabi nga, hindi daw dalawa ang puso, hindi pwedeng hatiin. So, dapat focus lang in one na wife or husband. So, public order, this pertains to public safety, although it has been considered to mean also the public welfare. Okay, so public policy, this is broader than public order. It does not pertain only to public safety, anything for the public good. Okay, so that's the public policy. So the ordinance, the different republic acts, okay, different laws that have been promulgated. Innominate contracts, so we said that there are some contracts that has no specific definition or designation. So it does not nullify that kind of agreement, but it is called innominate contracts. We're going to discuss later on what are the kinds of innominate contracts. Next na term is the stipulation for autrui. This is a stipulation in favor of a third person who has the right to demand fulfillment provided he communicates his acceptance to the obligor prior to revocation by the obligee or original parties. So this is an example yung sa ating sa subrogation, sa novation, no? There is a subrogation, expromission, third party. So it's not the original party to the contract, but later on being transferred all the rights. Okay, so and then gi-communicate niya doon sa obligor prior to revocation by the obligee of the original parties. So here there is the third party or the third person, not originally the party to the contract, but because of the agreement of the parties plus the acceptance, so na-transfer na yung rights to this person. Okay? So also we have the solemn contract. This requires formalities prescribed by law. So sa ceremony, for example, na celebrations. So this is an example of formalities prescribed by law. We're going to discuss further naman later. Counter offer, it is acceptance of qualified by condition, which is rejection of the things, no? So counter offer. So for example, A offer to sell his vehicle for 500,000 and B, the prospective buyer offered to purchase it at the price of 450, and that is counter offer. Earnest money, so it is a partial payment of a purchase price and is considered as proof of the perfection of a contract. So here, if A, for example, offers something to sell, and B, the prospective buyer or the interested buyer gave amount or money to A. So that means to say, okay, I will buy it. Okay, I offer my vehicle worth 500,000. And then sabi niya, can you offer it at 450? I will get it. I will buy it. Okay, sabi niya, sure, okay. So, yun, yung sabi niya, okay, here's 1,000 as my down payment for the price of 450 and give me, for example, sabi niya, and then I will pay the rest tomorrow. Okay, so yan sabi niya. So, that's earnest money. So, that means to say the 1,000 pesos that has been given by B to A will be deducted to the purchase price of 450. So, yung balance na lang is 449. Another term is the lucid interval. We know very well that a person, in order for a person to enter into contract or a contract to be valid, a person must be, or the parties must be in their proper mind, no? So, proper mind. So, not insane, not imbecile. But there are some instances na a person that is declared as insane and for some time, ano siya, lucid interval. So, no, gaabot-abot lang halimbawa ang kanyang pagkabaliw, no? Baliw siya ngayon for 2 months. Tapos next month, kasi wala na siyang problem, wala na mga stress masyado, so na okay na yung kanyang mindset. So, that person is in his or her lucid interval. So, it is a temporary period of sanity. So, a person who was declared as insane but later on experiencing lucid interval can able to enter into contract because is on the lucid interval. So, that's the temporary period of sanity. Although, hindi mo alam, baka next week na naman, nabaliw na naman siya. But, as long as that person, the party can establish an evidence that during the time that that insane person, upon agreement, no? So, he's on the lucid interval. Siyempre, ikaw maintindihan mo rin minsan kung baliw ba talaga siya or hindi, di ba? So, the way she talks or the way he talk, okay, or speak, no? So, malaman mo kung baliw siya or hindi. And then we have here the term the mistake of law. This is an ignorance of some provisions of law or from erroneous interpretations of its meaning or conclusion of legal effect of its meaning on the part of one of the parties. Of course, no? Even lawyers, even mga associate justice nga ng Court of Appeal, even the judges in the RTC, in the MTC class, karoon din yan minsan ng mistake of law. Mistake in the interpretation, erroneous or mistake in the interpretation of the meaning or conclusion as to the legal effect of the law. Okay, so kaya nga meron na pag there's a case in the MTC, sometimes if the person or the parties are not satisfied with the judgment, they're going to appeal it to the RTC. So, kung hindi pa rin talaga sila satisfied with the judgment, mag-appeal na naman sila with the Court of Appeal. And then the Court of Appeal will going to recommend, most especially to those mga heinous crime class. No? So, the Court of Appeal will just going to recommend to the Supreme Court. No? To the Supreme Court, either they're going to convict or dismiss or modify the penalty given by the lower court. So, hindi talaga perfect kasi marami nga siyang interpretation. Okay, so we have another term that is the future inheritance. So, yung ine-expect mo na ma-inherit mo class, no? So, sinabi nga natin, with this future inheritance, you are just expecting something. So, that means to say, the person na nag-expect ng something is hindi talaga na perfect pa yung kanyang right with that inheritance. So, halimbawa, buhay pa yung both parents mo. So, may lupa kayo. So, future, iniisip mo na future. But some way, binenta ng parent mo. So, wala ka nang ma-inherit. Okay? So, in Kuwait pa lang yung right mo. So, sabi nga natin, you cannot sell your future inheritance unless that inheritance was donated to you inter vivos, no? Kasi most of inheritance, if your parents will going to die intestate, so ibig sabihin they died without the will, so yun pa, magkaroon kayo ng right, ma-ripen ang inyong right towards that inheritance. But before, buhay pa sila, you cannot sell your inheritance because in Kuwait pa yung right mo. Half, hindi pa nga, no? So, parang hilaw pa daw. Kay remunerative cost, it is cost which pertains to past services rewarded. So, remunerative. Okay, motive. So, the motive, this refers to the private reason which a party has in entering a contract. So, what is your motive? Iba ang motive sa intent class, no? So, what's the intent? Ang intent mo is ibenta ang lupa. Ano yung motive mo? Kasi sabi mo, pag mabenta na yung lupa, ay maka-travel ka na all around the world. Okay? So, maka-date ka na with your girlfriend. So, mga ganon, no? So makapasikat ka na dito sa inyo nga barangay, kay damo ka kwarta. After 1 year, wala na, ubos na. So iba ang motive sa intent. So that's the reason. Private reason, no? Private reason, parang reason behind your consciousness ba? Sa isip mo. Oh, hindi mo naman sinasabi yung motibo mo, di ba? So yan. No? So yan yung private reason which a party has in entering into a contract. So ano yung motive? Next, we have the lesion. So that when we say lesion, it is a damage caused when price is unjust or inadequate. Okay, so man-discuss natin yan later. In Article 1305, this refers to a contract that is a meeting of minds between two persons. So yan, dito yung na-define yung contract. So there's always a meeting of minds. No? Meeting of minds, not only one person siya lang may gusto, or else that contract will be declared as invalid. Okay, so contract versus obligation. So obligation, di ba inuna natin ng discuss, because obligation is broader than a contract. Contract is only one source or sources of obligations. So ang obligation is so broad, and the contract is only one of the sources of obligations, while obligation is the efficient cost arising from the perfection of the contract. Siyempre, pag na-perfect na yung contract, meron ka ng obligations. Okay. So, obligation to pay, obligation to deliver the things that you sell, for example. Obligations to make signature so that that person can transfer the title to his name, for example. Okay? So, yun yung mga So, obligation may exist in the absence of a contract. Okay, class? Yes, that's true, no? Obligation, because contract is only one source of obligation. That means to say, there are some obligations where there is no contract. But, there is, in contract, there's always obligation. We have here, as I said kanina, we have here the kinds of innominate contracts. So, what's innominate contract? So, absence of designation by law does not make a contract invalid. So, halimbawa, contract lang. Agreement, simple agreement. Wala namang kang sinabi dyan na contract of mortgage, contract of sale, okay, no? Contract of marriage or marriage contract. So, wala siyang designation, basta nag-agree lang. Diba? Every day in our lives, you always have a contract. Uy, daanan mo ako mamayang hapon na sabay tayo mag-uwi. Okay, that's already a contract when other parties agreed. Okay, sige, hintayin mo lang ako. Okay, so next naman. So sabi niya, oy, ikaw muna magbayad sa akin ng pamasahe ha, kasi wala akong change, babayaran kita bukas. So nung pumayag siya, that's a contract already. Okay, so we have here examples of innominate contracts. We have do ut des. So, what does do this mean? I give you, so you may give. So, in this case, this is a contract wherein one is expected to give something and another will also give another things. So, bagay. Parang barter lang. I will give you rice, you will bring bayan. No? So, I will give you paper, and you will give me ball pen. Another innominate is do ut facias. So, I give you, so you may do. So, what are you going to give? No? I'm going to give you sahod, for example. So, you are going to do the things that I let you do. Okay? So, facio ut des. I do, so you may give. So, dito naman, ikaw naman yung gumawa, at siya naman yung magbigay. Okay? So, ito naman sa employer, no? On the part of employer naman ito. Ikaw yung empleyado, so at the end of the month, babayaran ka ng sahod. So, facio ut des. Another is, we have the facio ut facias. I do, so you may do. O, parehong services, parehong intangible things ito siya, class. Yung sa do ut des, it refers to giving of things, something that you can hold. Whereas in facio ut facias, that is something that you can do. Okay, so I do it, you may do also. Okay, so I wash your clothes, you're going to answer my assignment. Okay, so that's I do, so you may do. Oh, I polish your shoes, so you have to sweep the floor. Okay, yan. So, example, simple lang. So, that's a simple na contract. So, is there a need for a designation? So, no need, no? As long as there is an agreement and then there is a meeting of mind. Elements of a contract. Letter A, we have the essential elements. What are these? These are the consent, object, or subject matter, and cause or consideration. So, essential. The contract will not be valid without this. No? Object, consent. Kaya nga kanina, in-explain natin yung sa lucid interval. Kasi ang person that is insane cannot give consent. The same with the person that is considered minor, unless the minor misrepresent himself. Okay, we also have the natural elements. They are presumed to exist in contracts unless contrarily stipulated. So what's an example of natural elements of a contract? Although it is not specifically stated in the contract, somebody that is selling goods, hindi naman siya surplus, hindi naman siya ukay-ukay, so there's always a warranty against hidden defect. So for example, bumili ka ng television, pagpunta mo doon, i-check ninyo, o di ba, okay naman siya, okay naman. So nung dinala mo sa bahay, naku, blurred na masyado. So there's a hidden defect. Wala naman, di naman siya nabagsak, wala naman nangyari doon sa kanya, pero pagdating doon sa bahay ninyo is nag-iba na, or maybe mahina masyado ang volume. So that's the natural elements of the contract. There's always a warranty against hidden defect, not unless pinorchase mo yan sa surplus at pinorchase mo yan sa ukay-ukay. Kaya syempre, balaan mo na siya nga, alam mo na yan siya na used. So may defects talaga. Whereas pag mga brand new, so there's always a warranty against hidden defect. When we say hidden defect, that is not visible to the eyes at the moment na na-perfect ang contract. At the moment that you paid and then you are expecting na that certain goods will going to function very well, but later on, you found it out na hindi pala. Okay? So we also have the accidental elements. These are stipulations that the parties may agree on. So, in addition, ng other na mga conditions, di ba? In a contracts, the parties are free to stipulate whatever conditions they wanted to have, as long as, sabi natin, it is not contrary to law, public policy, public morals, traditions, and customs. So, ito siya, no? Kung ano pa yung dinagdag na mga stipulations ng parties, pwede siya class. So, yan yung accidental elements. We have here the stages of contract. Siyempre, preparation or conception, politisation, the negotiations between the parties. No? So, kahit magbili nga ng isda, magkano ang kilo ng isda? Sabi niya, tag 350. Oh, sige, pili-pili siya. Tapos sabi nung tendera, uy, masarap yan siya, masarap yan isabaw, masarap yan isigang, benta-benta, negotiate yan siya dyan. So, preparation, no? Ina-anticipate na magkaroon sila ng meeting of the minds. So, yung tiningnan yung hasang, tiningnan naman yung mata, okay naman, okay sa 350. Minsan sabi niya, ay, hindi naman to fresh ang isda mo. No? So, tingnan mo ang kanyang hasang. Tingnan mo ang kanyang mata, blurred na. Pwede 330 na lang. O, ganon. So, kung pumayag, there's already a perfection. Minsan, pumapayag naman yung tindera, pero nagadabog-dabog pa, no? Oo. So, ang problem naman din kasi sa Filipinos, sa gusto nila yung malaki masyado ang kanilang profit. So, unlike doon sa mga Chinese class na kahit konti, basta may ginansya lang, hinay-hinay basta kanunay. Okay, second, we have the perfection. Siyempre, kung nag-agree na sila, perfect na, okay, siling niya, sige. Okay, bigay ko na lang sa iyo ng 330 kasi ano man, binamano. So, yon. So, gikilo niya na. So, pag kilo, nagbayad siya, And then, yung binigay niya na yung isda, so there's already termination. Consummation, binigay na, termination of the parties. So, part of the obligations thus considered as executed or completed or terminated by mutual agreement. Problema lang sina, pag uwi niya ng bahay, nagkati ang isda, so babalikan niya, oy, makati man pala yung isda mo, Sabi naman nung tendera, ay sige, change. Makati ba? Fresh mo nito. Sabi niya, hindi Makati, ito dala ko, tingnan mo, tikman mo. Okay, Makati nga. So sabi niya, sige, change na lang natin ng another. Ito, priskong-prisko talaga. So ganun, na? Okay, until totally terminated ang contract. Okay, so next we have here the Article 1306. The contracting parties may establish as stipulations. So, yan sabi natin. Stipulations, clauses, terms, and conditions as they may deem convenient, provided they are not contrary to law, morals, good customs, public order, or public policy. So, ibig sabihin, ang parties that entered into contract, free. They have the autonomy of will. Kahit yun sa marriage contract, pero ang law kasi nag-provide class na if the persons, the husband and wife had already been married, the celebration of the marriage is already finished, and then maggawa sila ng agreement, hindi na pwede. Kasi nga, yung under the law, dapat prenup. Kaya may prenup tayo. Prenuptial agreement ang tawag nun, class. Kasi kung if you have an agreement na after na ng kasal, hindi na. Kasi it's the law that becomes binding, It's already the law. Pag wala kayong agreement as to the property mo, as to the income, before kayo kinasal, so ibig sabihin, absolute community of gains with the effectivity of family code. So, magiging absolute community of gain. Whatever you have, even during your single, at magiging property na yan ng family. So, magiging absolute community of gain. So, yan. Pero kung before nagkasal, nag-agree kayo na yung whatever pera, lupa, kayamanan na meron ka will remain to you. So, ibig sabihin, yung fruits lang. Hindi naman yan remain to you class kasi ano pang purpose ng pagpakasal nyo? Yung fruits, halimbawa you have an apartment, ang rental gagamitin din sa pangangailangan ng family. Hindi ibig sabihin na sabi mo, ay akin talaga yung apartment, may prenuptial tayo. Kaya nga minsan nag-agree sila, sino yung magbili ng bigas, sino magbayad ng kuryente, sa mga ganun. Kasi pagpapakasal is my obligation din. Hindi yan siya totally na-extinguish with the prenuptial agreement. Okay. Next, moral, good customs, public order, yun ang sabi natin. Another principles or characteristic of a contract, syempre, when you have a meeting of mind that's to become obligatory force, it has already a binding effect to the party. Sabi nga natin, in every obligation, the parties have to follow the principles of good faith. The same with contract class, because you agree, you have a meeting of minds, okay? So, obliged or binding kayo doon sa nagrihan. And what is expected by law is, you have to comply it in good faith. Kasi kung hindi mo i-comply in good faith, most especially in the contract na formal, solemn contract, so you will be charged of breach of contract. Okay, so perfection by mere consent. So yan class, when you consent, maski minsan hindi pa nga na-deliver, na perfect na ang contract. Hindi pa na-deliver yung sasakyan, pero nag-agree ka na ikaw ang bibili. So there's already a perfection of the contract. So not unless siguro for some emergency cases na nag-change ang mind mo, na hindi mo siya bibilhin, you have to inform the other party as early as you can. Okay, also, another characteristic of a contract, aside sa obligatory perfection by mere consent or consensuality, there must be a characteristic of mutuality. So, mutual. inoffer, di ba? Sabi natin kanina, there's a preparatory, there's a negotiation, and then there's perfection, and then mutuality. So, nalaman, no? Alam ng isa kung ano yung mga conditions, mga clauses, mga terms, and then mutual kayo. Ay, ibig sabihin ba, there's a mutual understanding as to the terms, as to the conditions. Kasi, pero minsan may mga instances talaga na iba yung pagkaintindi. Most especially if the other parties has a lower educational background, di ba? Ginapapirma lang na diretso bala class, no? So, pagpa-sign, hindi naintindihan masyado doon. But, generally, when you affect your signature, unless you can prove na there is a fraud, no? So, there is a fraud na ginamit so that you were able to put or affix your signature. So, pwede pa mang maanal ang contract. Okay. So, there is a mutuality. So, dapat dalawa talaga kayo. Both parties are bound by the contract. So, it is validity or compliance cannot be determined by one party only. Kasi nga sabi natin, it is a meeting of minds between two parties. Hindi po pwedeng si first party lang lahat ang masunod at mag-follow na lang si second party. So, dapat na-agrihan ng dalawa at nagbigay consent. Next, relativity principle. This Article 1311 is stated as a general rule that a contract takes effect only between the parties, their assigns, and heirs. This, however, has exemption when the rights and obligations are not transmissible by the nature. For contracts involving personal qualifications, okay, example na. So, personal qualification to paint. So, pwede mo ba na i-transfer? No? Sabi nga, relativity. Kasi ang contract, di ba, pwede siya ma-transfer sa assigns. Anong assigns? Yung representative. Kung sino yung representative na authorized representative, pwede din na ma-assign siya doon sa kanyang mga heirs. Oo. Pero, there are some exemptions na there are some contract na cannot be cannot be transferred. Such as contract to do. No? You're going to do the painting. Okay, marunong ka talaga kung kuha mo paano mag-paint ng Mona Lisa. Na disgrasya ka na na-fractured ang bones mo. So, hindi na maganda yung ng kamay mo. So, you cannot transfer it to your son. You cannot transfer it to your wife. You cannot transfer it to somebody kasi ikaw mismo. Personalize yan no? Okay. So, ang gawin, you have to terminate your contract. Okay. So, another stipulation. So, kung may stipulation na nag-prohibit ng transmission. So, kung nag-agree kayo na there is stipulation na walang transmission, ang original parties lang talaga, pwede yon. Provision of law. So, contract of agency, partnership which prohibit continuity, rather extinguishment. Diba, contract of agency, diba, sa agency, ang agent, nag-represent siya ng principal. Usually talaga yan, class. Pag may ahente, sino nire-represent ng agent? It is the principal. Parang nagiging sub niya lang si agent. Pero sino ang mag-liable niyan? Si principal. Kung ano mo yung i-promise ni agent dyan, bringing with him the name of the company, so ang company ang magiging liable. Pero, halimbawa, gi-terminate na ni company ang agency, contract of agency ni agent, so he's doing it in his personal capacity. Okay? So, yan yung ibig sabihin ng mutuality. Next, we have here, who is the third person in the contract. Okay, these are cases wherein strangers or third persons are affected by a contract. So, who is a third person class? So, third person is one who has not taken part in the contract and is therefore stranger to the contract. Hindi naman siya kasali, di ba? Minsan, yung contract of marriage, mag-asawa, pero nakikisawsaw si biyenan, nako, sira talaga yung buhay ng newly wed na couple. Kasi nakikisawsaw. Dapat hindi kasi siya nakikisawsaw. So, he has no standing in law to demand the enforcement of contract or question its validity. Kasi generally, it's only the party to the contract. Not unless siguro, yung binenta ng other party is owned by the third person. No? Pwede siya doon reklamo, syempre, kay ang gibenta mo. No? Gimisrepresent lang ng seller. So, as a general rule, a third person has no right and obligation under a contract to which he is a stranger. Hindi din siya pwedeng singilin kung, halimbawa, si tatay may utang, namatay si tatay, hindi pwedeng singilin ang anak. No? So, ang pwede lang is, pag may naiwan na property si tatay, okay, unahin muna abayad yung mga creditors bago nila hati-hatian ang naiwan na kayamanan ni tatay. Problema kung wala sang may naiwan, charge to experience ang creditor. Okay, so not unless ma-prove ng creditor na it really redound to the benefit of the heirs. Pero generally, hindi pwedeng ang utang ni Juan ang magbayad ay si Pedro. Okay. So, yan. So, contracts containing a stipulation for a true will. So, pwede kung na-specify sa agreement. Contracts creating real rights. Ano yung mga real rights? Yung may mga copyright. Di ba sabi nila dati si Freddie Aguilar ba yun? Sino ba yung namatay na singer na meron siyang mga songs na gina-reproduce. So, pwede yun siya, class. Kasi real rights, may copyright siya doon sa mga songs na kanyang inawit. So, whoever ang mag-reproduce ng mga songs, dapat meron pa rin, makakuha pa rin yung heirs. Makakuha pa rin yung mga heirs niya ng royalty fee na 10%. Kasi pag copyright, meron kang 50 years during your lifetime. So, halimbawa, na-create siya at the age of 20, nagiging 70 ka, meron pa rin yun, no? Lifetime, you have the right pala over your creation during your lifetime plus 50 years after your death. Yun pala. So, yan, no? So, yan yung real rights. So, contracts creating real rights. So, pag i-reproduce, mga producers, yung mga heirs, maski hindi nakasulat doon, basta ma-prove mo na you are one of the heirs, so pwede kang maka-claim for royalty fee. Contracts which had been violated at the inducement of the third person. So, ito yung mga exemptions. So, generally, ang third person is not liable for whatever or not bind to or obliged to do the stipulations in the contract unless that person violated or induced the other party to the original contract to violate. Kaya siya man nag-induce na i-violate ng either of the party, so siya ang magbayad, siya ang managot. Yan ang sabi ng batas. Kasi 'di ba, meron ding mga parties to the contract na dali lang idoy no? Idoy lang ng iba. So nag-breach na siya ng naagrihan, no? Okay, so at the expense or at the damage of the other party to the contract. So ng third person nga nag-instigate, na nag-induce para ma-violate ang conditions of the contract, pwede siya magiging liable. Okay, class? So, dito lang muna tayo mag-end sa third person. So, next natin na lesson is the stipulation for true will and its requisites and other rights. Okay?